Live.
Hi guys, welcome to LegalDesk.com and BHIVE presenting Go Legal today. What is this event? What is this webinar about? This webinar would cover aspects which would include how to name your startup, what kind of structure to choose for your startup, what will be your registration procedure, and what are the important agreements. So before we go into the details, let's just go into as to how to choose a name for your startup. Why is it important to choose your name carefully? So it's important to choose your name carefully because your name is your identity. Exactly like how your name is an identity for yourself, your company's name or your brand name is a very important identity for your company or your brand. So what names you should not choose? Please do not choose any name which has a prefix of state, India as prefix or suffix. Why? Because India and state, these are suffixes which are in fact used only by companies which are government companies by nature, for which you will read, it will be considered a state under Article 12 of the Constitution. So in that case, obviously, you cannot represent yourself to be a representative of the Indian government by any chance. So that is why you should avoid using names such as India or state. What else should you avoid? You should avoid using names which are existing names. What do you mean by existing names? For instance, you cannot use names which are already well known in the market. Which are the names which can be said to be well known in the market? To consider an example, let's refer to Whirlpool as such. Whirlpool is a company which is well known in the market. So, for example, if you decide tomorrow to name your company Whirlpool or your product as Whirlpool with respect to washing machines or any particular product, for example, fridge, that would not be an advisable idea. Therefore, and plus you will have to pay royalty for that. So that's something which you should not do. So please do not use existing names. Generic names. You cannot use yourself a name which you cannot be differentiating your product from any other product. So it cannot be a generic name. So you should be very careful while choosing a name it has to be descriptive of what you do, but it cannot be exactly what you do. That is what I mean. So for example, I am LegalDesk.com, but I cannot be legal.com. It doesn't make sense. It cannot be law.com. It doesn't make sense. So that is why you cannot use generic names. Offensive words. I think that is pretty much obvious why you should not use offensive words. It is okay for common parlance, but not while you name the company. What names you should, how to choose your name? Make sure when you choose your name, you reflect and think about the industry which you are referring to. What do I mean by that? I mean, like for example, I am in a legal space, and in legal space, people who come in the legal space or who deal with the legal space or who are likely to deal with you will identify you if you are able to hint towards the fact that you are dealing with legal space. So therefore, you have to be very careful with the industry you deal with. For instance, if you go for chartered accountants, they generally use and partners or and associates because it gives a reminiscence or a thought to the person who is dealing with you that maybe this person is dealing with that particular space. So therefore, you be very careful about the industry which you are in. Domain name. You have to be very careful whether the name you are choosing has a particular domain name available. So why is that so? Domain name availability is very important because right now and in this era, everything is supposed to be online, everything is global, you get customers globally, you make a name globally, your reputation is at stake globally. Therefore, domain name is very important, so make sure domain name is available. Trademark search. This is something I think we all consider as a layman that we are very smart enough to use the website, therefore we are very easy to go ahead and use the trademark website to conduct trademark searches. It is not that easy. Why is it not that easy? It is not that easy because, number one, trademark searches are a bit complicated because you will have to conduct searches which not only refer to a particular word or a particular line, but it is about how you enter that line or where in that trademark would the line be. So therefore, trademark searches are very important, and therefore it is very, very, very pertinent that you let that experts handle that, and you should not go ahead and do that yourself. Regulator approval. Why are regulator approvals needed? Regulator approvals are needed in cases where, for example, with respect to finance or insurance, these are the sectors where regulator approvals are very necessary. So these are the common things which you have to keep in mind while choosing a name for your company. And for instance, now if I go a bit forward and talk about your company incorporation rules itself has guidelines as to how you choose the name for your company. So that guidelines in 2014, the name should not be offensive, it should not be an abbreviation. So there are a lot of certain criteria which are laid down. So be very careful while naming your company to not to break such guidelines. So what else is very important is that your trademarks. So what is trademark? Trademark is a form of your IPR. So let's go into the broader picture as to what is IPR. Intellectual property, it's as clear as that and as simple as that. It can take various forms in India. In India, intellectual property is trademark, copyright, your patent, your industrial design, your geographical indications, and protection of plants and varieties acts and everything. So protection of plants and varieties is something which is going into too details of the scope, so I will not be dealing with that right now. So starting with the patent. When is a patent given? In order for patent to be given, you have to prove that it is an invention, you have to prove that it is a novel invention, and you have to prove that the novel invention can be used. So basically, novelty, uniqueness and usefulness are very important criteria for a patent to be recognized in India. So for how long a patent is given in India? A patent is given for 20 years in India and not more than that, and after the 20 years elapse, it comes into the public domain. So in another instance which is very important for patent is, why is patent very important, is that you can exploit the patent, you can assign the patent, you can sue for infringement of the patent, and you can license the patent. Patent registration is mandatory in India. For example, if you have an idea in mind, so a very common question which arises is that, can an idea be patented? Prima facie, on the face of it, no, it cannot be. But what can you do? If an idea is something which you can reproduce, or if you can give a vague idea, so you can get a provisional patent done. Provisional patent, as in you can file a provisional specification with the patent authority. What is a provisional specification? Provisional specification is where you specify that a patent is obtained on this. I wish to obtain the patent on these particular grounds, but the condition is that you have to file the complete specification of the patent within 6 months of filing the provisional patent. So what is the procedure? So the procedure is that you file the application for patent registration, then you file the provisional or complete specification, and then when the specification is accepted, it is published, then it is request for examination, then the examiner gives his report, and in case of an objection, there is an amendment to the patent, and then finally there is a grant of patent. And as I said earlier, it is only for a period of 20 years. Next, I come to the important aspect which probably most of you would be dealing with. Most of every company, in fact, deals with this issue as such, that is the issue of trademark. Why is trademark such an important thing? Trademark is very important. Why? It gives an identity to your brand, as I said at the very first instance. It's just not only your name. My name of the company might be something else, but my trademark might be something else. But it's as important as your name. For instance, like if I have a particular company and I name it a particular thing, but I do not want that to be reflected in my brand name, I can do that. But it is very important that people know that this brand name belongs to a particular company. For example, Uber. Uber is a very important trademark. So if tomorrow somebody in the road, another taxi comes with Uber, it will mislead the customer or it will mislead the consumer. So you're not supposed to mislead anyone. So the second thing which is inevitable, which is important with respect to trademark, is the fact that your trademark cannot be deceptively similar also. It has to be distinctive. Your trademark has to be distinctive. Why? Not only for your identification of your business, it is not only that. It is also important because a trademark is your identity and it is the one which separates you from any other particular identity in that picture. Therefore, that is the importance of having a trademark. So what is the trademark procedure, trademark registration procedure? Submission of an application. And where should you submit the application? You have to submit the application in your principal place of business. So it is what you decide is your principal place of business that matters, number one. And number two, if you have only one place of business, then that will be your principal place of business. If you do not have a principal place of business in India, then in that case your place of residence will become your principal place of business. What is the representation? So where you file the application, it is very important to give the representation of the mark. For instance, if there is a particular way your mark is written, or particular way you want to write a particular way, like for example, this would be your LegalDesk's trademark. So therefore, the way LegalDesk is written here, that itself is a trademark. That itself distinguishes me from my competitors. So that is very important. So therefore, the representation has to be filed. After that, in case it's something known as a convention application also. So for instance, you have filed, so there is, if India has entered into a treaty, or India is into a convention country with any other country for that matter, and if it's a recognized agreement, in that instance, that in case you have already filed an application in that particular country, in that case, when you file a patent in India, within 6 months if you file it, in that case your trademark, you get a priority over any other application for the same trademark. So that is why if you have a convention country application, this is how it is supposed to be filed. And then what is important is classes with respect to trademarks. So you have to be very careful when you choose the classes. This is something which is specified in the Act itself. Therefore, again I tell you that it's very important to consult experts in these matters, because that is what we are here for. I mean, that's as simple as that. Then advertisement is given, and in case if there is any objection which comes into the picture, at that point of time, a hearing is given to the parties, and in case it is successfully done, then the trademark is registered. So it's as simple as that. The process is not that difficult. So trademark filing is a simple process as such, but the thing is, you have to do it very carefully, and if it is not done carefully at the stage of interim injunction also. So what is interim injunction? Let me give you a brief background of that also. So if you go to the court of law, in case of infringement of trademark, there are two reliefs if your trademark is infringed. Number one is infringement. Number two is passing off. What is the difference between infringement and passing off? Infringement is, for instance, I have a registered trademark. My trademark is registered and somebody else uses it. The relief which that person can claim for is infringement. If I have not registered my trademark, but I have been using my trademark, and my trademark is being somehow associated with me, I have been able to establish a particular reputation with that trademark, I have established some amount of goodwill with that trademark. In that situation, even though my trademark might not be registered, I can sue the other party for passing off of the trademark. Like for instance, domain name. I have a domain name registered, my trademark is not registered with the trademark registry, but I have been using the domain name before any other particular person. So the prior usage is very important for trademark. Now we will come to the next aspect of it, which is the copyright. What is copyright? Copyright is given over your literary, dramatic, sound, artistic, movie recordings, musical work, etc. So what exactly is copyright protection? Copyright protection is given for 60 years plus the lifetime in addition to the author's lifetime. So after the author's lifetime, for a period of 60 years, your copyright protection is given. So what is protected and what is your importance of copyright protection? Number one is goodwill and number two is monetary compensation. So both of them are very, very important. There are certain instances, however, where a court would not give you copyright protection. One of those instances being if it is the work is already in public domain, or number two, if it is used for educational purposes. In that case, the copyright protection is somehow the court is not in favor of granting that copyright protection, and that is very clear from one of the recent happenings of the Delhi High Court judgment in the case where it held that if I have to copyright, I have to photocopy certain important material from any textbook and it is sent to, I am using it for educational purposes. In that case, it is not copyright violation. But nevertheless, that order was challenged before the division bench, and the division bench has not come up with a clear verdict on that right now. But then that is the picture. So in case if it is used for a particular purpose, educational purposes, for instance, in that case this copyright protection is not granted. So again, copyright your remedies are civil and criminal. And how is copyright filed? Copyright is filed along with the fee of with the DD and PO. That fees will something which is different for different particular products. Then the diary number is issued to you, and there is a mandatory waiting period of 30 days. So after the mandatory waiting period of 30 days, if the copyright receives objection, in that case the entire thing of objection clearance and hearing of parties, and then finally filing the scrutiny report and everything comes into the picture, and that then is decided as to whether copyright is granted or not. In the case there is no objection, in that case it is again scrutinized by an examiner and he files a scrutiny report, and if there is no discrepancy found, then the registration is approved. In case the registration is approved, whatever is the important extract is sent to the party, and that's how you get the copyright protection. So that's how it works. So now we come to design registration. So what is design registration? Design registration is when it deals with basically not the process or invention as such, but how the particular process or invention is, a particular form of that product, or a particular way that product is designed. For example, in case of whether it be your BMW or your Ferrari for that matter, if the entire process itself is a different process, in that case it will be patented. But however, if there is a particular way the engine is formed, or that is why that the particular engine way, the way it is formed is very special or very different, in that case is what is granted your design protection in India. Again, the protection amount a year, number of years for which the protection is granted is around 10 years plus another renewable of 5 years is granted with respect to your design protection. So that is how design protection is dealt with. Then if you come to geographical indications, now this is something which is very interesting as a entirely new something which has come up. So what is geographical indication? Basmati rice, everybody knows it, right? I mean, basmati rice is something which was Indian product for a long period of time. But then a US company started claiming that basmati rice is they made some particular rice and called it basmati rice. So when it comes to the export, and India's exports really suffered when that happened. So that's when the geographical indication part comes to be very important. Say for example, if a particular thing is made in India, and that particular specific thing has a recognition of being from a particular territory or from a particular part of the territory, in that case is where the geographical indication comes into the rescue. So that is the whole concept of your IPR. What do you do to be careful when it comes to your IPR protection? So what is to be done? There are 5-6 things which you can be very careful about. Number one is to conduct an audit of your IPR. What do I mean by conducting an audit of the IPR? IPR audit would mean that you have to make sure that what are exactly the products which what do you mean by IPR protection? What is the products which you have? Like for instance, I would be dealing with bottles, like a particular, probably Coca-Cola for instance. So Coca-Cola has a bottle. You can, in fact, the bottle will be your trade dress. That's how it is. The tag, the Coca-Cola's ribbon, that special ribbon that Coca-Cola has, that itself again becomes a trademark. The way the bottle is shaped becomes one particular thing. The process and the procedure, how the Coca-Cola is made, or the color of the bottle, everything in particular, the Coca-Cola as a name, every particular thing is something which is an IPR, it's an intellectual property. So that is why it should be protected. Second thing is very important is that you should have your non-disclosure agreements and confidentiality agreements in place. In the era of startups, because we are dealing with startups right now, you have to be very careful with these things. Why do you have to be careful with these things? You have to be careful because number one, the number of people who come into the attrition rate which is set in an organization when people join and people leave is very high in the area of startups. Therefore, a non-disclosure agreement makes sure that that person does not go out and leak out the essential data or trademark information of your company, the important information of the company. For this instance, I'll tell you a small, there's this Formula car racing which happens in internationally. So in that case, if you see that in case there's this I'll not name the particular team. There was this one team which had a group of consultants. There were around 5-6 consultants with them. There was some dispute with the team and the consultants. Therefore, the consultants left that particular team and joined another team and leaked out information there. Even though a confidentiality and non-disclosure agreement was there, that confidentiality and non-disclosure agreement did not clearly specify as to what was the confidential information and what was the extent of damages. So these are the things which you might think it's a very easy thing to cut, copy, paste from some place and make an NDA, but that is not advisable, because that is something which there are experts are there for. And why are the experts needed is you have to be very careful when you draft. So you have to be careful as to what is the definition of confidential information and to how many years it should not be disclosed. And points like these are very important when you draft your non-disclosure agreements. Number 3, again as I said, domain name. Check your domain name availability. You do not want to land up in a soup because of you having chosen a domain name which is already there in existence, or somebody else is using it, or it is there in prior usage and that person has made a reputation for himself. It's not only unethical, it is something which is not permitted by the law as such. So I would advise that please be very careful while choosing your domain name. Another thing which you have to be very careful about is the fact that in case if you are covered under the Startup India exemption, about which I will deal with in another 5-10 minutes down the line. Startup India exemptions, there's something called as SIPP, that is you are given a special protection in case you have come under the eligibility criteria of startup exemption. In that case, you get facilitators for startups who help you with the filing and processes and all. But for that, there is a very strict criteria. In other cases, obviously, you have people like us who cater to that need, who help you with the registration of your trademark or patent or copyright for that matter. Another thing which is very important is putting on disclaimers in your website. Why are disclaimers necessary? For instance, you are a social media you are something which is a social media website as such, which makes two people coordinate with each other, talk to each other. The content which is posted there might either be defamatory. There might be instances where the content is plagiarized. These are instances which you can do nothing about, right? I mean, there's even though you might take precautions, but there are certain instances nothing can happen about them. So what do you do in that situation? You put disclaimers on your website, and that is how disclaimers come to your rescue. What are the disclaimers? Put disclaimers stating that anything which happens with respect to your plagiarism, copyright thing, should be the responsibility of the author. In that case, your liability, though not completely reduced, it limits your liability for only your acts and not for the others' acts. That's when the terms are very important for your website and your disclaimers are very important. These are the things which you should not go without, and for your IP protection, I suggest you should go with it. Now, I've spoken a lot about IPR. I think I've covered it extensively, and any other doubts, you feel free to leave your email ID and the query on the comments section of the Facebook Live video, and we will get back to you on any query which you have. Next, I will deal with your structure of your startup. What are the available structures? Let's deal with that first. The available structures are your sole proprietorship, your partnership, LLP, that is limited liability partnership, your one-person company, that is a new concept which has emerged. One-person company has emerged 2013, after 2013. Then you have private limited company, and then you have the public company, so which I think most of us are aware about. So let's start with the sole proprietorship as such, as a model. So what is sole proprietorship as a model? And a lot of people, in fact, when I get queries, when we get queries, the maximum number of queries is why sole proprietorship, what is the difference between a sole proprietorship and a one-person company. So the difference between the sole proprietorship and one-person company is something which I will deal with in a minute when I tell you about one-person company. Let's deal with sole proprietorship. How do you start a sole proprietorship? You need two registrations in place, and then you're good to go. you do not need you need a registration under the Shops and Establishments Act, which is specific from state to state. So you have to be very careful as to not go for the generic thing, or generically do not file it. Take the help of experts in filing the Shops and Establishments Act application. So for Shops and Establishment Act application is filed, then you need a PAN card. So your PAN card will serve as your sole proprietorship PAN card also. You do not need a separate PAN card. So because your income, the income of the sole proprietorship will be treated as your income. So you do not need any other particular but in case of sole proprietorship, there are certain features which are not very safe for in particular if you want to run the entity for a long term. What is not safe? Number one, the liability is unlimited. By that I mean that in case if somebody decides to sue you for your acts, or in case you have debts, in that case you are completely liable to pay the debts off, then your personal assets are also liable to be taken off in that case. So that therefore sole proprietorship is not a very safe model to go by. The next model, which is generally used in our country, also a lot of people use this model, is the partnership model. What is a partnership? Partnership is regulated by Partnership Act of 1932. Partnership, so basically Partnership Act provides that your partnership can be by way of an oral agreement also, or a written agreement also. But why should you have a written agreement in place? Because that will be your primary proof of your having a contract done. So when you go to the court of law, if in case of any future dispute, you will be able to prove your partnership with ease. It will be very easy for you to prove that there is a partnership in place. What if there is no partnership agreement? You may ask. So in that case, the court goes into the intent. So just because you are sharing profit with somebody, it is not a conclusive proof that you are in a partnership. But in case that you are sharing the profit, it is one of the important proof, but it is not a conclusive proof. So what is the difference between important and conclusive? It is very simple. Important is it will be considered by the court of law. It will be given a due weightage, but that will not be the sole criteria for deciding whether your partnership is a partnership or not. So to avoid all this confusion, you should have the entire deed in writing. Again, partnership deed is something which is optionally registrable, but again, it's always better to register your partnership deed. So it somehow gives a degree of stability, a degree of safety, a degree of accountability to the other partners as well. So what is the, in case you do not have a partnership agreement in place, what is said to be the partnership profit sharing ratio? It would be around 50-50. It will be considered to be equal until and unless the partnership deed provides otherwise. So what about addition of partners? Addition of partners can be done in a partnership, but that has to be done with the consent of all the other partners. So what is said to be the consent of all the other partners? Consent of all the other by consent of all the other partners, I mean that it does not have to be a written consent as such, but if your partnership agreement provides that it has to be a written consent, in that case it will have to be a written consent. So basically partnership deed will be your charter. It's kind of a charter to your partnership coming into place. What about admission of minors to partners? Minors cannot be admitted to the liability of the partnership, but they can be admitted to your benefits of a partnership. Therefore, with respect to minors, when they attain the age of majority, it is within their idea to whether ratify the partnership or get out of it. So, if within 6 months of attaining majority, they do not exercise the option of getting out of the partnership, then it is presumed that they are within the partnership. So that is with respect to minors of the partnership. So this is partnership. The next important form of business which I would like to speak about is your limited liability partnership. The limited liability partnership is governed by the LLP Act of 2008. So what is the difference between limited liability partnership and partnership? It is actually as simple as it sounds by the name of it. with respect to limited liability partnership, the liability of partners is limited. While partnership, you have the option of getting the partnership deed registered. In LLP, you do not have that kind of a discretion. It is compulsorily registrable with the Ministry of Corporate Affairs itself. So MCA is where you register your LLP also. So why should you get your why is LLP preferred over partnership is because of the limited liability, and why it is not preferred over private limited company is because of the fact that you cannot get investors or funding within LLP because they prefer private limited company for their funding, and you can actually issue shares. So with respect to that, I will come to the private limited company part of it later. Let's just deal with LLP as such. So what is again another feature of limited liability partnership is that earlier, before 2006, there's a latest clarification which says that your limited liability partnership requires to be limited liability partnership, though it can earlier there was a provision which says that it can be converted into private limited company earlier, but there was no provision as to how it will be converted. But now that conversion is somehow become possible because of certain amendments into the Act and certain rules which have come into the picture. So now the next kind of entity which I will be dealing with right now is private limited company. The most famous kind of an entity, I would say, and it is most preferred over the other entities. Why is it preferred over the other entities is very simple. The simplistic answer to that is funding. Especially among startups, all startups go by the basic idea of getting their organization funded at a later point of time, because it is very difficult. It is very difficult to run an organization on your own funds. Till what time would you go with your own funds in an organization? At some point of time, you will have to look for funding, and for that, private limited company is the most opted for kind of entity. So, with respect to registration of the entity, I will go with that in around 2 minutes. Before that, let's just talk about the important feature of a private limited company. So, with respect to private limited company, now the new Act restricts the maximum number of members in the private limited companies to 200. So the members in the private limited company are restricted to 200. The liability is again limited. My bad. The private limited company, your liability is limited. Your number of members is 200, and you have to have a particular registered office. You have to have a place where your company is registered and it is it's operating from. One of the directors in your company, you have to have a minimum of 2 directors. One of them should be a resident of India. By resident of India, I mean that 182 days he must have been in India at that point of time, and that is what I mean by resident of India. So therefore, you have to be a resident of India. What is the most important feature of a private limited company, except for the fact that it is a limited entity, as in liability would be limited. So apart from that, what is it? The right of transferability of shares. So there is no free transferability as such, which comes with a public company where your shares are treated as securities, but not with respect to your private limited company. In a private limited company, the simple thing is that you have to go according to your articles of association. Your article of association becomes like a charter document. It is how your company has to be governed. So any agreement you might have outside the company, you might get into a founders agreement, you might get into a shareholders agreement. In case it is not reflected in the articles of association, and if it is in contravention with the articles of association will take a primary view. The court will take into account your article of association. Why? Because it is your charter document. So article of association being that important a document, you have to be very careful while getting it drafted. So another thing which most of the private limited companies have in picture and have in their line of action, in their article of association for that matter, is something called as a right of preemption. What is the right of preemption? Right of preemption says that for instance, there are 3 shareholders in the company and one shareholder wants to transfer the rights to a person outside the company. In that case, right of preemption says that that person will first have to offer those shares to the people who are inside the company, who are already members of the company, at the rate which is either already given in the Article of Association or according to the formula which is already given in the Articles of Association. So, right of preemption is one of the ways to restrict the transferability, but though you can restrict the transferability, you cannot completely prohibit transferability of shares. That is something that the Companies Act says, that you can be your restriction on transferability might be very low or it might be very high, but it cannot totally prohibit the restriction of transferability. So, how exactly to get your company registered? It's a good news for a lot of us that in October, in fact on the day of Mahatma Gandhi Jayanti itself, the new SPICE forms were introduced by the Ministry of Corporate Affairs. So what are SPICE forms? SPICE are integrated forms. So you will ask, what is completely different about SPICE forms, since integrated forms was already available under INC 29. So what is INC 29? INC 29 was a form which was used earlier, which was again an integrated form, but now the integrated form provides that it is all electronic. So it is all imbibing and it is all electronic, and there are a lot of regulations which have come into place and which have taken away the requirement of getting stamped. A lot of your requirement, I will not say it is completely eliminated all the requirements, but a lot of the requirements have been simplified and you do not require your stamp paper for a lot of your requirements. So, what is different is, number one is that now Memorandum of Association and Article of Association, which were being manually printed and then uploaded, are now in an electronic form automatically. In the website itself, they provide e-form 33 and e-form 32 for that matter, and which helps you to file the documents electronically itself. So while filing it electronically, you might ask that what if I want to add an article, what if I want to delete an article, or in case of entrenchment of articles, what do I do? In that, all the provisions have been made in the form itself. So it has been simplified to quite a few extent. It has been simplified. Now it is much easier to get your company registered. But there are certain mandatory conditions which have been imposed. One of them being that PAN and Aadhaar are necessary in order to file your SPICE forms. Aadhaar has become mandatory, and why has Aadhaar become mandatory? Because they have done away with a lot of your identity requirements, that is identity proof requirements, in case you already have a director identification number. So in case you have already procured a director identification number, in that case you do not have to attach your identity proofs to your SPICE forms. Earlier that was not the case. Now it is, though the restriction of using only one name is there in SPICE also, just like the INC, where you can choose only one name for your company, but the good news is that they have linked these forms to your INC one. Therefore, you can choose 6 names. You can check the availability of 6 names and then choose your one name and then go ahead with it. So that discretion has been given with respect to your SPICE forms. But the condition being that in case there is a foreign director in the company, or there is the first subscriber to the company is a person who is from foreign origin and who does not have a valid DIN in India, in that case you cannot go with this SPICE forms. Then you have to go with the traditional method of filing your INC set and going ahead with it, which is unlike your INC, which is your SPICE forms. So in case it's a foreign subscriber, in that case SPICE forms is not applicable. And another thing is INC 22 required to be filed? INC 22 is not required to be filed with SPICE if a company is registered with the address of correspondence only. So the next question which arises is that does SPICE simplify things for you? Yes, SPICE does simplify things for you, and also one of the conditions which SPICE has is that you have to get an EPFO registration done if you are getting PAN through SPICE. Therefore, your EPFO, the Employee Provident Fund thing, has to be done through the SPICE itself. So that is one of the important ingredients when it comes to SPICE forms of it. Another question which comes into effect is also whether SPICE covers one-person company. Yes, SPICE does cover one-person company also. And no, it does not cover LLP. So there are two questions which are very simplistically handled by the SPICE forms. For more information on that, you can easily refer to the MCA guidelines on SPICE form itself. They are given in FAQ section. And for even more further analysis with respect to SPICE forms and features of SPICE forms, you can visit our website LegalDesk.com to get into more details and in fact get your company incorporated. Next will be your one-person company. What is a one-person company? Earlier there was a restriction on Companies Act 1956 that minimum number of members has to be 2 with respect to a private limited company. But with respect to OPC, the things have been simplified. What is being simplified is that with respect to OPC, you can be the only member, you can be the sole shareholder, but you can start your private limited company. So what about in case the OPC dies? What will in case the one person in whose name the OPC is dies? What about in that case? In that case, a nominee has to be appointed just in the very beginning when you are registering your OPC, so that that particular aspect of it is dealt with at a later point of time. Therefore, that clear guidelines and mandates have been set, then the Act itself provides for it. What is the usage? You have to be very careful while selecting your name. It should be OPC, whatever -- OPC Private Limited should be the name of the OPC, particular OPC. Can an OPC be converted into a private limited company at a later point of time? No, not voluntarily. OPC will be, so if the particular, there is a particular amount, and if you cross that particular turnover, in that case OPC will be automatically converted into a private limited company, but you do not have a discretion to convert it into a private limited company. Therefore, again, funding by way of issuance of shares is not possible in an OPC, because again there has to be only one. Excuse me. Next, I would be dealing with the important agreements which you need to refer to. The agreements which you require, in fact, for successfully after incorporation or before incorporation of your entity. What are the agreements? In brief, if I have to tell you what the agreements will be, you have to make sure that in case you have more than one founder in a company, in that case you require to have a founders agreement in place. You might ask, why should I have a founders agreement in place? To settle certain aspects of your business relationship, or how will with respect to how the IPR, who will be the person who holds the IPR, who has more duties with the particular startup. In all those cases, founders agreement will come to your rescue. Again, another very important clause in your founders agreement is your vesting clause. What is a vesting clause? A vesting clause basically means that, for instance, today if I am allotted a shares, my entire shares, I won't have the right to own the shares, the complete shares, until and unless a period of 3 years or 6, whichever years which is mentioned in the particular agreement between you and your co-founder. If that till that period elapses, you cannot become you are not liable, you cannot transfer the shares. And if you get out before that time, the shares will not be vested in your name. So the vesting clause is one of the most important clause in case of your founders agreement. Next, with respect to in case you are getting your investors into the company, in that case it's very important to enter into your term sheets. What term sheets will specify as to what is the investment which will come in, what is the time period in which it will come in, how many shares will be issued, how the shares will be issued, how will be the value of the securities be determined. All that will be covered in your term sheets. thing which is very, very important, as I mentioned very early in fact when I started this entire module, what I started this entire module was that your non-disclosure and confidentiality. At that point of time I was dealing with your employment part of it. Now I am dealing with the complete aspect of it. Not only your employees, anybody who deals with your company. It might be your vendor, it might be a person who's freelancing with your company. It is very important to have a non-disclosure agreement in place and a confidentiality agreement in place. It is your discretion if you want to have a non-circumvention clause. So what is a non-circumvention clause? A non-circumvention clause will mean that you, a particular person, you restrict the other person from competing against you. So that means that it's also called as a non-compete clause, to say it simply. So non-compete clause will mean that you are not supposed to compete with me for a particular period of time for competing businesses, and you will not take away. It is called non-circumvention, also a non-solicitation. That means my existing clients, the company's existing clients will not be taken away by anything. So that is very important. So non-disclosure. So when you are entering the agreement, you might have vendors, you might have partners, you might have clients in the future, but you have to be very careful to enter into the NDAs. Next very important is if you are entity which is an e-commerce entity, you need to be very careful with the fact that there are intermediary guidelines in place. So therefore, you have to be very careful that you have your terms of your website well written and well drafted. Do not try and copy paste the same, because you have to be very careful while drafting, because no two terms can be the same. If your company is doing the exact same thing as another company, then in that case then your company is actually not needed in the market. Therefore, obviously there will be a point of distinction between what you do and what another company does. So in that case, therefore, it's very important to have your terms custom drafted by some expert, and that's how LegalDesk helps you. I'll come to the fact that how LegalDesk will help you with respect to all this at a later point of time. But there, yes, terms, your privacy policy. What is a privacy policy? Again, privacy policy is stating is a simple statement which states that these are the ways that how will we handle the data which a particular person enters while he is using a particular website or using a particular module. So in that case, if you are receiving data as to how you will be used, whether you will be placing cookies on their computer or not, whether you will be collecting information from a person who is minor by age, all these are very important information, and all these disclosures have to be made in the privacy policy itself. You also have to be very careful that you publish excuse me. You have to be very careful that you publish your terms and privacy policy at a place which is very visible to the naked eye. Another thing is that in case you are dealing with vendors or independent contractors for that matter, in that case have a vendor agreement in place. Why is vendor agreement necessary? You might say that word of mouth, India operates in the entire system of word of mouth for a long period of time. So it is now that it has come as an exception that there are vendor agreements in place, and people are not very comfortable entering into vendor agreements. But it is a safety mechanism. Half the disputes which are there in the court of law can be settled if you have an agreement in place. It can be settled much quickly as compared to if you do not have agreement in place. If you do not have agreement in place, everything goes back to circumstantial evidence and everything is that difficult. So why get into the difficult mode of it than come into the simple mode of it? So simple mode of it, though at the very beginning it might entail a particular cost to you, but for at a later point of time, that exact small amount which you put in the beginning will save a lot of expense for you at the later part of it. So therefore vendor agreements are very important. People wonder as to why are there agreements everywhere and why is word of mouth not that preferred, because in our country it is all friendships and relationships and everything is covered. But I know it is people in the West have in fact gone ahead to go into prenuptial agreements. So to come into an agreement with your business partners is in fact advisable. I mean, in fact, it's advisable and is one of the expenditures which you can go ahead as it is a cost which is a necessary cost. It is not something which is a wasteful expenditure, it is a necessary expenditure. So please get into a proper vendor agreement. So these are the important agreements which you would be requiring. Next comes to how would you hire people in your organization, and what policies and what are the particular agreements and policies which are important with respect to getting people into your organization. So one of the most important thing is have your employment contracts in place. Why are employment contracts necessary? As I said earlier, it's no different. Employees might come today, employees might go tomorrow, but what they bring in and what they take out, it will be a win-win or a loss situation for you as such. So a good employee is an asset, but if an employee leaves the organization in between and you do not have a contract in place, you do not have any way of stopping that guy from sharing any information, from leaving the organization without notice. You will be left high and dry. So therefore, what is very important is having an employment contract in place. Another important document which is necessary in every organization is your HR policies. Why is an HR policy necessary? HR policy is necessary because it lays down what are the conditions which you want to impose, in the sense as to what will be the dress code if you have any, what is the timings of the organization, how many leaves the person will be entitled to, the employee will be entitled to. All these are very important aspects of a person retaining a particular person in your organization, and that is the reason why HR policies are the need of the hour. Next thing which in fact a lot of organizations ignore, and it is a sorry state of affairs. A lot of organizations ignore, and it's a sorry state of affairs, is your sexual harassment at workplace policy. So sexual harassment at workplace policy is mandatory for organizations with more than 10 employees. So why do people not follow it? Because there are no stringent provisions and nobody is coming and inspecting. But for most of the organizations, this ignorance will lead to an issue at the later point of time. So you need a sexual harassment policy at the workplace, you need an internal committee in your workplace, and all these are very important documents to go ahead with and very important guidelines to follow with respect to you coming into having a good, successful, happy organization in place. Not only for your adherence perspective or your compliance perspective, what I'm talking about here is the safety of your employee as such. So an employee will feel safe if you have a committee in place. And though you might say that it is again a wasteful expenditure and who will put so much of time, but let's say if your organization is troubled due to the act of one of your employee who is not probably a good name to your organization, you would not want that. So it's always better to have a sexual harassment workplace policy in place. You need to have ESIC registration, that is Employee State Insurance Corporation registrations, Employment Provident Fund registrations. All these registrations have to be in place in order to have and hire any employee successfully. Next, I want to talk about for a minute about your Startup India plan. So Startup India initiative protects any company which is turnover of less than 25 lakh, turnover of less than 25 lakh. It has to be less than 5 years old in the entire industrial space, and it has to come up with a new invention or a new process. In that particular thing, it comes in the Startup India plan. Another important thing about Startup India plan is you need a recommendation letter from your incubator. When a recognized incubator has to give you a recommendation letter, then you can come to the Startup India plan, and you have a lot of tax exemption, as well as you do not have compliance exceptions, but you might have inspection exemption. By that I mean a lot of inspection authority which happens annually in an organization will not happen for a period of 3 years from the time you register as a startup under the Startup India plan. So all these are very important perspectives. In fact, the Startup India plan only recognizes entities which are registered entities. Therefore, that is another reason why you should get your entity registered. So to cover it all up, how does LegalDesk help you in the same? LegalDesk helps you with respect to your incorporation right from the very beginning. That is,
It helps you with incorporation. It helps you protect your ideas by getting your intellectual property registrations done. It helps you, gives you legal consultation. That's why our startup package is in place. You can visit our website www.legaldesk.com and go to our startup package page and get to know more about our startup packages. Then we have agreements in place. We have they are available in a do-it-yourself model in which you can enter a few fields and get an agreement online. Or, in case you do not find it online, you can use our custom drafting request, that is request service button and request for documents, and we will get back to you with a quotation and we will draft the document within a minimum time at a very minimal cost. That is how LegalDesk helps you with it. So, wish you a happy legal year ahead and a happy new year. Namaste.